introduce you to Justice Dennis Curran, who has been a justice in our district court system, superior court system, 15 years. He's a graduate of the Boston Latin School and got his master's degree from the University of Pennsylvania in law school at the University of Virginia. His entire resume is in the booklet that you have, so I won't go through it with you. Judge, let's see what you can do winging it without
Sure.
stuff.
Well, thank you, Judge. And it's a pleasure to, good evening and welcome, and it's a pleasure to be among history aficionados. I don't get this opportunity very well. Every November I go down to the Lincoln Forum in Gettysburg, Pennsylvania, and that is a real treat, I must tell you. Tonight's program focuses on the trial of Susan B. Anthony. A lot of people aren't aware that Susan B. Anthony was placed on trial in a federal court, And we'll talk about the sequelae that happened to her as a result of that. So I'll start off with a quotation that Elizabeth Cady Stanton said sometime in the mid-19th century: "The best protection for a woman is courage." It was 101 years and 4 months ago that the first woman legally cast her vote for President of the United States. And what led to that remarkable day? Well, a tremendous amount of hard work and sacrifice. So we begin our intellectual journey tonight with images that remind us of the tenor of the times. If you can just visualize, women were subject to derision, to humiliation, to violence, and they used the democratic process in an everlasting patience, working the way it should to result in the enactment of the 19th Amendment, which took place almost 105 years ago, 100 and something years ago. In any event, so with the passage of a century, we tend to forget the fierce political battle between the sexes that gave women the right to vote. The first woman, however, to vote for President of the United States wasn't 105 years ago. It was actually cast in November of 1872 by Susan B. Anthony in a courageous, right here, in her later years, in a courageous effort to test the United States Constitution to exercise what she believed was her right to the franchise. For her effort, Anthony was jailed and tried, and in the end, her vote was not counted, but it did galvanize a country to mobilize, or a part of the country to mobilize, organize, and strategize, and eventually convince men to give women the right to vote nearly 50 years later. Here is how Susan B. Anthony saw the issue, and we'll have a couple of readings tonight. First one is by Linda.
It was we, the people, not we, the white male citizen, nor yet we, the male citizen, but we, the whole people, who formed the Union. And we formed it, not to give the blessings of liberty, but to secure them, not to half of ourselves and the half of our prosperity, but to the whole people, women as well as men.
Who was Susan B. Anthony? Well, she was a Massachusetts native, born and raised in Adams, Massachusetts. She was involved in social activism at the early age of 16, and later a lifelong friend to Elizabeth, the famed Elizabeth Cady Stanton. Anthony believed in rights for married women, and those rights included, if you can believe this, in the mid-19th century, the right for a woman to speak in public. Can you imagine? The right for a woman to speak in public. Forget about the right to suffrage. The right for a woman to speak in public. The right to a vote, obviously, and finally the rights for married women, of which there were basically none. They were property. So When Susan Anthony, at age 32, attended her first women's rights convention in Syracuse in 1852, and I must digress here, the history books, almost all of which I've read on this subject, have it completely wrong. Elizabeth Cady Stanton and Susan B. Anthony did not meet in the first Seneca Falls Convention, which took place 4 years earlier in 1848. I will tell you, the history books, it is amazing when you get into the original research how many errors there are historically in carrying the story forward. And obviously people are lazy and they don't do the original research. But I'm sharing with you tonight, it is a historical fact that Susan B. Anthony didn't attend the first Seneca Falls Convention. It was in 1852, the second one. She declared at that time that, quote, the right which women needed above every other, the one indeed which would secure to her all the others, was the right of suffrage. And Anthony spent the next 50 years of her life fighting for the right to vote. She worked tirelessly, giving speeches, petitioning Congress and state legislatures, and publishing a feminist newspaper called The Revolution, all for a cause that wouldn't succeed until the ratification of the 19th Amendment 14 years after her death. So we start our legal discussion tonight, and I'm not going to get into the legal weeds on this, but I'm just going to give you the tip of the iceberg to know how Susan B. Anthony thought they had the right to vote. First of all, we start with the women's suffrage amendment, and that reads as follows. This is the one that went into effect 100 years ago, about 100 years ago. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Those are the critical words, on account of sex. Now, however, Anthony would not have the satisfaction of seeing her vote drop through the opening of a ballot box. So our story begins in Rochester, New York, on November 5th, 1872. And the event, and the trial for illegal voting, that's what it was called, she cast an illegal vote that followed, created an opportunity for Anthony to spread her arguments for women's suffrage to a wider audience than ever before. So let's talk about that vote. You see, Anthony had been planning to vote long before 1872. She had taken the legal position and argued it whenever and wherever she could, that the recently adopted 14th Amendment gave women the constitutional right to vote in federal elections. But now the 14th Amendment came out of a trilogy of constitutional amendments, the 13th, 14th, and 15th. 13th obviously abolished slavery or involuntary servitude, and the 14th we now know as the Due Process and Equal Protection Statute, Equal Protection Constitutional Amendments. So let's look at the language of that 14th Amendment, and I apologize, we would normally have had these on the screen for you, but we're doing the best we can. All persons, listen to this language, born or naturalized in the United States are citizens of the United States and of the state wherein they reside. No state can abridge the privileges of citizens of the United States. Now you say to yourself, well, that's pretty clear. All persons, right? All persons. We look back now and we say, well, obviously a woman is a person, right? No, not legally. A woman was not a person. Neither was a woman a citizen. Can you imagine? I mean, the Rices would be turning over in their grave if they heard these arguments made in 1695. So the amendment said that all persons born in the United States, or naturalized in the United States, are citizens of the United States. And as citizens were entitled to the privileges of citizens of the United States. So Susan B. Anthony's way of thinking, and it's not that bizarre, those privileges included the right to vote. The problem, however, was that Susan B. Anthony and her allies failed to read or chose to ignore, purposely, Section 2 of the same 14th Amendment, which said the following. When the right to vote at any election is denied to any of the male inhabitants. Imagine that. You see how they've taken number one is, Section 1 is all persons, and now we've restricted it to all male inhabitants of such states, being 21 years of age, are in any way abridged. So they've taken Section 2 and narrowly defined it to just males. And she also, meaning Anthony, furthermore ignored the clear language of the 15th Amendment. 13th, 14th, and 15th Amendments are known as the Civil War Amendments. 13th pushed by Lincoln, 14th and 15th after his death. Now, what does the 15th Amendment say? The right of citizens, there's that word again, of the United States shall not be denied or abridged on account of what? Race, color, not creed. They weren't that far ahead. Or previous condition of servitude. In other words, blacks or African Americans down in the South could vote. So it's the black suffrage. But black suffrage for who? Males. Males. Any mention here of sex? No. No. As you can see, there's no mention in any of those amendments of extending the franchise to women. No mention of sex in the 15th Amendment. In fact, the 14th Amendment specifically, as I recall, as I read to you a few moments ago, refers to male inhabitants, and twice to a male citizen in the same paragraph regarding the right to vote. So you see where the legal argument is here? Now, I didn't write these words. Obviously, I wasn't even a twinkle in anybody's eyes, but that's the way it was. That's what the drafters of those amendments in the mid-19th century meant, obviously meant. But one lawyer who was married to a suffragette thought that the language of Section 1 of the 14th Amendment could be interpreted as allowing women to vote. And that was all Susan B. Anthony, Elizabeth Cady Stanton needed to hear, was one lawyer. So they published the lawyer's analysis in their newspaper, which was called The Revolution, and urged women to vote. And when denied the right to vote, they intended to sue. So on November 1st, 1872, just before the presidential election, every 4 years, Anthony and her 3 sisters entered a voter registration office set up where? In a barber shop. You might as well have set it up in a saloon. We know who only goes into a barber shop, right? It's not a hair salon, right? So obviously they didn't want women to go into the barber shop, and I'm sure they probably had rules in those days that you weren't invited. They were part of a group of 50 women that Anthony had organized to register in that hometown of Rochester, New York. When they entered the barber shop, the women saw 3 young men serving as election inspectors or registrars who were stationed in the barber shop, voting registration office. Anthony walked directly up to the registrars, and as one of the registrars later testified, demanded that we register them as voters. Obviously, they refused Anthony's request, but she persisted. We've heard those words before, haven't we? Quoting the 14th Amendment citizenship provision and the article from the New York State Constitution pertaining to voting, and that provision of the State Constitution of New York contained no sex qualification. Interesting. The registrars were unconvinced. And finally, according to one account, Anthony gave the men an argument that she thought might catch their attention. I think this is Linda.
If you refuse us our rights as citizens, I will bring charges against you in criminal court, and I will sue each of you personally for large damages. I know I can win because I have Judge Sheldon as a lawyer. There is no shortage of money to back me.
The inspectors were stunned. They sought the advice of their supervisor, who told them that they should allow the women to take the oath of registry. Young men, he declared, do you know what the penalty of law is if you refuse to register these names? Registering the women, he advised, would put the entire onus of the affair on them. I don't think that's quite the right analysis. But in any event, I think he just did the easiest thing that he could do and figured throw the ball into somebody else's court. In all, 14 Rochester women successfully registered to vote that day, leading to calls in one newspaper for the arrest of the voting registrars who complied with the women's demand. And one newspaper editorialized, and this is Rich.
Citizenship no more carries the right to vote than carries the power to fly to the moon. If these women offer to vote, they should be challenged. And if they take the oaths and the inspectors receive and deposit their ballots, they should all be prosecuted to the full extent of the law.
Thank you very much, Rich. So the crime. Sounds like a mystery novel or a murder case or something you'd see on Netflix or PBS. Soon after the polls opened for the presidential election of 1872, Anthony and 7 or 8 other women cast their ballots. The registrars voted 2-1 to accept Anthony's vote, and her folded ballot was deposited in a ballot box by one of them. One of the registrars testified later as feeling caught between a rock and a hard place. Quote, decide which we may, we were liable to prosecution. He's right. We were expected to make an infallible decision inside of 2 days of a question in which some of the best minds in the country are divided. That's a little bit of an exaggeration. In any event, 7 or 8 more women of Rochester successfully voted in the afternoon. There goes the Republic, right? Anthony's, now here's an interesting historical tidbit. Anthony's vote went to elect Republican Ulysses S. Grant and all the Republican slate, straight Republican ballot, based on that party's promise to give the demands of women a respectful hearing. The Democrats weren't even giving them a hearing. Later that day, Anthony wrote of her accomplishment to her close friend and fellow suffragist, Elizabeth Cady Stanton.
Dear Mrs. Stanton, well, I've been and gone and done it. Positively voted the Republican ticket, straight, this AM at 7 o'clock. The Democratic paper is out against us, strong, and that scared the Dems on the registry board. How I wish you were here. All the suffragette women would work to this end of enforcing the existing Constitution supremacy of national law over state law. What strides we might make this winter. So all right, I hope you voted too. Affectionately, Susan B. Anthony.
Now, I researched the issue of whether Elizabeth Cady Stanton did vote, and indeed she did not. So Susan B. Anthony was out there swinging in the wind. All right? Now, I'm not saying, maybe she had other things to do, I don't know. But anyway, she didn't vote. Susan B. Anthony's vote triggered a major controversy in the days that followed. A Democratic poll watcher filed a complaint charging Anthony with casting an illegal vote, challenging both Anthony's registration and her subsequent vote. A United States commissioner, it's an archaic term, but we would now call them a United States magistrate, but it was called a United States commissioner in those days, acted on the complaint and issued a warrant for her arrest. The warrant charged Anthony with voting in a federal election, quote, without having a lawful right to vote and in violation of, quote, the Enforcement Act. And I'm going to talk about that in a few moments. What is that? It was enacted in 1870, and I'll tell you why it was enacted in that year. Civil War had just ended 5 years before. What's going on? Agitation among the blacks and the radical Republicans in the North for the right to vote for blacks. But they wanted to restrict it, so they enacted what they call an Enforcement Act. And in any event, to prevent what they considered, what the white Southerners considered to be blacks who they didn't want to vote, if any. So the law carried a maximum penalty of $500 or 3 years in prison. That was the Enforcement Act. Let's speak about her arrest. Her arrest was delayed, meaning Susan B. Anthony's arrest was delayed for 4 days to allow time for the United States commissioners to meet and discuss the case with prosecutors in the United States Attorney's Office in New York. Eventually, a United States Deputy Marshal showed up at Anthony's home and arrested her. When she arrived at the jail, Anthony was surprised to learn that among those arrested for their activities were not only the 14 other women voters, but also the election registrars who had authorized their votes. They're all in the pokey together. I mean, you can't make these things up. Anthony's lawyers refused to enter a plea at her time of arrest, and the United States Commissioner scheduled a preliminary hearing. Anthony was questioned at the hearing by one of her lawyers, who tried to establish that Anthony believed rightfully that she had a legal authority to vote and therefore had not violated the 1870 Enforcement Act, which prohibited only willful and knowing illegal votes. You see what the little, Doug, you'd appreciate this, you see the loophole that they're creating there? Because she wasn't willful and she didn't know it to be wrong. That was the defense. She testified she had actually sought legal advice from an attorney before she cast her vote. But she did admit that he told her that he hadn't studied the question. All right, so Anthony was asked, do you have any doubt yourself of your right to vote? She replied, not a particle. They postponed her case. And after listening to legal arguments, the commissioner concluded that Anthony probably violated the law. When Anthony, alone among those charged with Election Day offenses, refused to pay her bail, she was ordered held in the custody of a deputy marshal until the grand jury had the opportunity to meet and consider issuing an indictment. And in the materials that you have this evening, there is a copy of that indictment that I dug out. So it's a fascinating little document. There it is right here. This is the actual indictment. And they had never had such a case before, so they had to write in the language of what she had done wrong. This is most of it is a form, but in the back, in the bottom part, you'll see this is an Enforcement Act complaint, which would normally be used in the South or other jurisdictions where they didn't want certain people of race to vote. They added in the words, the said Susan B. Anthony, if you can see the handwritten words, being then and there, only lawyers can make up this stuff, to in person of the female sex. They had to write that in because they had never had such a case before. I find this document fascinating. In any event, Anthony saw the commissioner's decision to jail her as a ticket, her ticket to the United States Supreme Court. Well, where is it? It's on the right-hand side of the folder. I think it's the third item in there. It's before the remarks by Susan B. Anthony. In any event, that's the actual, a photocopy of the actual indictment. So Anthony, getting back to our story, Anthony saw her refusal to admit to bail as an opportunity to get the United States Supreme Court to review the case, and she began making plans with her lawyers to file a petition for a writ of habeas corpus. Habeas corpus, for those of you who had Latin years and years ago, is you have the body, you must release it, right? Not surprisingly, Anthony was also trying to make political hay out of her arrest. She sent off hundreds of papers concerning her arrest to suffragist friends and politicians. Anthony's attorney asked a United States judge to issue a writ of habeas corpus, ordering that Anthony be released, but the judge denied it. He then raised her bail from $500. Can you imagine that? $500 might as well be $100,000 today. He doubled it from $500 to $1,000. Anthony again refused to pay. Her own attorney, however, a male, decided to pay her bail. In doing so, he forfeited her right to get her case heard before the United States Supreme Court. When she found out about it, she was livid, and she confronted her lawyer, demanding he explain why he paid her bail. His answer, I could not see a lady I respected put in jail. Indictment. A disappointed Anthony still had a trial to face, a grand jury of 20 men. Women were not allowed on grand juries or on a jury, for that matter. Returned an indictment against Anthony, charging her with, quote, knowingly, wrongfully, and unlawfully voting, without having a lawful right to vote. The said Susan B. Anthony being then and there, here's those words again, a person of the female sex. So you have that indictment. The trial is set. Susan B. Anthony now goes on the stump. She uses the next 4 months before trial to educate the citizens of Rochester and the surrounding communities from which a jury would be drawn, interestingly. On the issue of women's suffrage, she took to the stump, speaking in town after town on the topic, repeatedly posing this question to the crowds. Is it a crime for a citizen of the United States to vote? Is it a crime for a citizen of the United States to vote? How succinct and compelling a question. Now, we all look back with historical hindsight 2020 and say, obviously the answer is yes, right? It wasn't at the time. Her exhausting lecture tour had taken her to every one of 29 districts in the county, and to many in her audience, she was the picture of sophisticated refinement and sincerity. She was 52 years of age at the time. She would look down at her audience, ranging from a few dozen to over hundreds and hundreds of people, and begin, and I think this is Linda's.
I stand before you tonight under indictment for the alleged crime of having voted at the last presidential election without having a lawful right to vote. It shall be my work this evening to prove to you that in thus voting, I not only committed no crime, but simply exercised my citizen's right guaranteed to me and all the United States citizens by the national Constitution beyond the power of any state to deny.
Thank you, Linda. So Anthony quoted the Declaration of Independence, the United States Constitution, the New York Constitution, James Madison, Thomas Paine, the Supreme Court, and several of the leading Republican senators of the day to support her contention that women had a legal right as citizens to vote. She also argued that natural law, as well as a proper interpretation of the Civil War amendments, gave women the power to vote. Her lecture tour began to worry her prosecutor. In a letter to Senator Benjamin Butler of Massachusetts, Anthony wrote, "I've just closed a canvass of this county, and I rather guess the United States District Attorney, who is very bitter, will hardly find 12 men so ignorant of a citizen's rights as to agree on a verdict of guilty." The prosecutor, however, convinced the federal trial judge. Interesting tidbit. This is a federal district court judge on the lower end of the scale. It's district court, circuit court of appeals, and United States Supreme Court. That's the layers on the federal level, not the state level, the federal level. So it's the lowest level of judge. It's a trial judge in the federal system. Interestingly, that judge, had been named as or nominated by the President of the United States as a justice on the United States Supreme Court while this case was pending, or just before this case started, actually, a couple of months before. And his nomination was being considered by the United States Senate at the time he presided over this trial. Interesting. The prosecutor argued that Anthony had prejudiced, do you think, potential jurors of the county. The judge agreed to move the trial to another county and rescheduled the trial. But Anthony responded by immediately launching a lecture tour in that other county. She spoke for 21 straight days in a row and concluded her tour the night before in the very town where the trial was to begin the next morning. Not an attempt to influence a jury, I don't think. Many observers were skeptical of the strength of Anthony's case. A New York Times editorial opined,
Miss Anthony is not in the remotest degree likely to gain her case, nor if it were ever so desirable that women should vote, would hers be a good case. When so important a change in our Constitution as she proposes is made, it will be done openly and unmistakably, and not left to subtle interpretation of a clause adopted for a wholly different purpose.
Thank you, Rich. So we now proceed to the trial, and here is how one suffragette saw the trial. Quote, "Susan B. Anthony is not on trial. The United States is on trial." We move on to the government's case against Susan B. Anthony, and at trial, the prosecutor made the following opening statement. We think on the part of the government that there is no question that whatever her intentions may have been, whether they were good or otherwise, she did not have a right to vote. And if she did vote without having a lawful right to vote, then there is no question that she's guilty of violating a law of the United States. And moving to the defense, they argued that Anthony reasonably believed that she was entitled to vote, and therefore couldn't be guilty of the crime of knowingly casting an illegal vote. And to support this argument, Anthony's defense attorney called himself as a witness. I wouldn't do this. I'm under oath, you know. It's one thing to say things that you want a judge to listen to. It's another thing to swear to them, you know. Before the last election, he said, Miss Anthony called upon me for advice upon the question of whether she was or was not a legal voter. I examined the question. The story changes, you see. Story changed. I examined the question and gave her my opinion unhesitatingly that the laws and Constitution of the United States authorize her to vote as well as they authorize any man to vote. So you can see the change in Anthony's position. It's funny how the story changes when they get to trial. I used to see this all the time as a judge. It just never surprised me. Right, Doug? The defense attorney called Anthony as a witness so she might testify as to her state of mind when she voted, and the district attorney objected. Quote, he said, she is not competent as a witness on her own behalf. She is not competent as a witness in her own behalf. Now, interestingly, and this is something that shocked me as a judge, and just absolutely shocked me. And I'm certain that most of my colleagues are not aware of this. At the time, a criminal defendant had no right to testify in their own behalf. Is that shocking? A criminal defendant could not give their side of the story. They could not. So let's talk about the denial of that right for a moment. We all assume that, I mean, doesn't that violate your notion of fundamental fairness, that the defendant who's on trial for his or her life or their liberty cannot testify in their own behalf? Well, here's where it happens. Here's how it happens. For centuries in both England and America, parties to a litigation, whether it be a criminal case or a civil case, were disqualified from testifying in their own behalf. Only, quote, disinterested persons were permitted to testify because it was believed at the time that a person who had a personal interest in a case would inevitably lie. Personal interest was thought to be so strong that it would overpower even the obligations of an oath, and swearing to tell the truth would not remove that disqualification. So, when a defendant was brought to trial in the 1700s or 1800s, no criminal defendant had ever advanced the novel claim in any American court that he or she had a right to testify in their own defense. Hadn't been advanced as a notion. And none would have done so until sometime after the Civil War, when the right to testify would gain recognition, mainly as a result of legislation. And where did that legislation start? In the state of Maine. And then Massachusetts followed soon thereafter. Now, although a defendant had no right to give sworn testimony, he or she did have the right to make an unsworn statement in open court. But interestingly, so this is a little footnote to this, this statement, which is sometimes called an allocution, A-L-L-O-C-U-T-I-O-N, had been traditional in criminal prosecutions in both England and America, but was only allowed after conviction. After conviction. After conviction. And the judge would say, does the defendant have anything to say before sentence is pronounced? So it's basically a throwaway. The defendant could say anything they want at that time and was not subject to cross-examination. But it's, frankly, let's be honest, it's a nullity. It doesn't affect anything. Returning to the Susan B. Anthony trial, the judge barred Anthony from taking the witness stand. The defense attorney opened a 3-hour-long argument for Anthony by stressing 3 points. I must tell you, I find this fascinating because in the olden days, lawyers could talk for hours. In the Amistad trial, Steven Spielberg's case about the La Amistad, the friendship ship, the slave ship in the 1830s that was seized, John Quincy Adams spoke for 7 hours to the United States Supreme Court. Nowadays, they have three lights, to the right: green, yellow, and red. You get 30 minutes. That's it. If you're in the middle of a word, they don't care. You're gone. You're gone. If you don't pace yourself properly, and it's very difficult to do. I've been there and seen it. I have not argued before the Supreme Court. I don't really want to. In any event, green obviously means go, yellow means you have 2 minutes left, and then red, your mic basically is cut off. And by the way, the United States Supreme Court, has anybody ever been there? No, raise your hand. Have you ever been there? It's fascinating. The lawyer has a podium here. The buttons are, the lights are off to the right. And the judges literally are probably 6 to 8 feet from you. Right there. It's very intimate where the lawyers are. And then you have the grandeur of the seats in the back. But in any event, the idea that a lawyer could speak for 7 hours, or in this instance, a 3-hour opening statement, is beyond the pale. As a trial judge, I used to say to the lawyers, you can take as long as you want. The problem is, let me just make the point. Let's say this is a remote control. Now, the rules of the court, which I bend, if a lawyer wants to take 45 minutes or 50 minutes, I don't really care. But he's talking to a jury, which is a remote control-oriented jury. If they get bored of you, what are they going to do? Turn you off. So I used to tell them, look, this is a remote control generation. If we don't like you, we're changing the channel. So then I could see them rewriting their opening statement on the fly. So they could talk as long as they want. And I think the smarter lawyers are just succinct and compelling and then make their point. And guess what? The hardest thing for a lawyer? Sit down. Sit down. So in any event, defense attorney opened the long argument. In those days, people did speak longer. And he said that she was being prosecuted solely because of her gender. And I think we're rich.
Circumstances, the act would have been not only innocent, but honorable and laudable. But having been done by a woman, it is said to be a crime. The crime, therefore, consists not in the act done, but in the simple fact that the person doing it was a woman and not a man. I believe this is the first instance in which a woman has been arraigned in the criminal court merely on account of her sex.
Thank you very much, Rich. The second argument was that Anthony cast a legal vote because of the recently enacted 14th Amendment. And Rich, I think you've got that too.
By the 14th Amendment, the United States have not only declared what constitutes citizenship, both in the United States and in the several states, securing the rights of citizens to all persons born or naturalized in the United States, but have absolutely prohibited the states from making or enforcing any law which shall abridge the privileges or immunities of citizens of the United States. By virtue of this provision, I insist that the act of Miss Anthony in voting was lawful.
Thank you. And finally, he insisted that even if the 14th Amendment didn't take, she couldn't be prosecuted because she acted in the, good faith belief that her vote was legal. Now the district attorney has his turn and he argues for 2 hours. And right after he finishes, this is at the end of the trial, the judge takes a piece of paper from his pocket and he begins reading his decision.
The 14th Amendment gives no right to a woman to vote, and the voting by Miss Anthony was in violation of the law.
Thank you. The judge rejected Anthony's argument that her good faith precluded a finding that she, quote, knowingly, end quote, cast an illegal vote, saying, assuming that Miss Anthony believes she had a right to vote, the fact constitutes no defense if in truth she had no right. She voluntarily gave a vote which was illegal and thus subject to the penalty of the law. The judge then surprised Anthony and her attorney. Now, there's a jury there. There's a jury there. They've heard the evidence. What does the judge do? And Rich, you're there?
Upon this evidence, I suppose there is no question for the jury that the jury should be directed to find a verdict of guilty.
In my legal career, I have never heard of a judge directing a jury to find guilt. I've never heard of it. All factual issues are decided by the jury. He took the case away from the jury, which was a highly unusual development, but probably politically smart. In her diary that night, and saved his Supreme Court nomination probably, in her diary that night, Anthony angrily described the trial as the greatest judicial outrage history has ever recorded. We were convicted before we had a hearing. The trial was a mere farce. Now, had the jurors had an opportunity to deliberate, it is possible that Anthony might not have been convicted. A newspaper quoted one juror as saying, quote, "Could I have spoken, I would have answered not guilty." And remember, in a criminal case, all you need is one vote for not guilty. And the men in the jury box would have sustained me. Sentencing. The next day, Anthony's defense attorney argues for a new trial on the ground that her constitutional right to a jury had been violated. It obviously had. Judge promptly denied the motion. Before sentencing, he asked Anthony,
Has the prisoner anything to say why sentence shall not be pronounced?
and the exchange that followed stunned the crowd. Anthony thundered that the judge had trampled underfoot every vital principle of our government. My natural rights, my civil rights, my political rights, my judicial rights are all alike ignored. And the judge, in a move calculated to preclude any appeal to a higher court, ended the trial by announcing,
Madam, the court will not order you committed until the fine is paid.
all right, so he takes the matter away from the appellate courts, leaves it in his hands, and gives the key to the jail to her, and she doesn't go to jail. She decides that she's not going to pay the fine. And he doesn't pull the trigger on it to send her to jail. So true to her word, Anthony never paid a penny of that fine. Her petition to Congress to remit the fine was never acted upon, but the government really never made a serious effort to collect the fine. Anthony tried to turn her trial and conviction into political gains for the women's suffrage movement. She ordered 3,000 copies of the trial proceedings printed and distributed them to political activists, politicians, and libraries. And in the eyes of some, the trial had elevated Susan B. Anthony to the status of a martyr, while for others, the effect may have been to diminish her status as that of a common criminal. Such were the times. In the eyes of some, the trial elevated Anthony to the status of a martyr. Many in the press saw Anthony as the ultimate victor. As one New York newspaper observed, Bill?
If it is mere question of who got the best of it, Miss Anthony is still ahead. She has voted, and the American Constitution has survived the shock. Finding her $100 does not rule out the fact that women voted, went home, and the world jogged on as before.
As only a newspaper editorial cynic could say it. Later in life, commentators said the trial was the greatest judicial outrage that has ever been recorded. Now, what's the significance of this trial? Well, it contributed in three ways to advance the principle of women's suffrage on three grounds. One, legal, political, and constitutional. First, in terms of the social significance, the press coverage for the women's suffrage movement was enormous. Second, there was a backlash against the trial judge for directing the verdict. And third, it eventually led to the enactment of the 19th Amendment. But the story doesn't end there. Our history here in Massachusetts on this issue is not so commendable. In 1915, the issue of women's suffrage was on the ballot as a referendum to amend the state constitution. It failed miserably. And here are the election results. A yes vote supported the constitutional amendment to provide women the right to vote. A no vote opposed the state constitutional amendment. Yes, 162,000 votes. No, 295,000 votes. So it was a defeated 35 to 65. And for all of her efforts of 50 years of toil, humiliation, derision, bullying, ostracism, her sacrifice for her principle, what do we have to show for it today? A coin.
A coin.
A coin. It reminds me of those t-shirts. My grandparents went to Bermuda and all I got was this t-shirt. Thank you very much.